are live. Welcome.
Hi, guys.
Welcome to the Speed Mooting Partners in Crime podcast. I'm John.
And I'm Hayley.
And this is the podcast where we talk about all sorts of things. Law, mooting, advocacy.
Life. Marriage.
Yeah.
Upcoming marriage.
Yeah, all sorts. So strap in for the ride, come for the law, stay for the other general
hijinks.
Chat. Yeah.
Although we got a bit of a troll, didn't we?
We got troll. I don't know if it's a troll.
It could have been a genuine question.
Yeah, it could have been a genuine. I mean, to be fair, it was posed as a genuine question.
Yeah.
So, at the start of the podcast, we like to, we've been doing a bit of an introduction, and generally we'd introduce the episode number, and we'll do that in just a second. And we must have spoken for some time about...
Sometimes we go on little tangents, don't we? Whatever's going on with us, Some people like it. Some people obviously...
One person obviously wasn't happy, so... hopefully, that person who commented, hopefully you're a genuine listener and you like to listen to our podcast. Bear with us for a few moments. I will be into the law shortly.
Yeah.
But no, thanks for the engagement anyway. We appreciate it. Any engagement is good.
Are we going to say what the comment says?
Go on. I think it was you that spotted the comment. So what did it say, Hayley?
When does the law start?
Well, when does the law start? Good question. It's a Speed Mooting Partners in Crime Law legal podcast. So good question. Maybe it was a genuine question. They were that keen for the law.
Yeah. On that particular episode...
7 minutes in. So in fairness, if you've tuned in for law and you're waiting for 7 minutes for the law.
Yeah, and maybe, you've never listened to us before, so you don't know who we are, you don't really care about us chatting about our wedding and other bits and bobs, you could just be like, when does the law start?
Yeah. Funnily enough, we've just run an advert on... Well, we're in the process of running an advert on Facebook. Wow, we've been trolled left, right, and centre. We've had to
delete a few comments.
Yeah.
Some people really don't like law.
There was one guy that really, really doesn't like advocacy. He went so far as to say he would rather eat fecal matter from his hand than take part in the advocacy club.
Wow.
Yeah. That's how much he dislikes advocacy.
He dislikes it that much, though, that he's obviously looking for things like that on Facebook.
Yeah.
Because the ad will only target people that have an interest in law or advocacy. And takes the time to leave us a lovely comment.
Yeah.
So thank you very much.
Thank you. Yeah.
I assume that one's been deleted.
That one was deleted very swiftly.
Yes. There's different theories on this, isn't it? I remember having a chat with your brother Alan about this, because he has a YouTube channel, shout out to... Target Slam, all about tennis, because he is a tennis coach, and he got trolled a little bit, didn't he, at one point? And I was like, just delete it, and he was like, no, I don't. He doesn't believe in deleting the trolls' comments and stuff. He leaves them there. He didn't even answer or acknowledge it, I don't think. Where I'm very much of the opinion, if it's a little bit, I can see there's a little bit of trolling undertones, but I think what. This could actually be a question that could help other people.
Yeah.
I will leave it on and answer it. Like we had another one on an old video about the Part 36 offers.
Yeah.
And someone left a bit of a sarky comment, but also, could be a genuine question. Why are the CPR rules hidden and kept so complex so only legal people can understand them? That was the gist of their comment. But I was like, someone could read this and it could be helpful. So I answered it and said, they are quite complex. That's why lawyers are legally trained and know how to break this down, like we've done on this video, etc. Yeah. But when someone is just trolling us, or if I try and answer back politely and they continue trolling, they don't get the time of day from me, and I don't leave them on our platform. So if you troll us, you will just be deleted.
You will, because at the end of the day, we work very hard for what we do. We've come from nothing, and we're trying to make this profession more accessible. That's why we have this podcast. That's why we do all the things that we do.
Yeah.
And, as you say, a sarky comment, fine. And we'll come back and, we'll answer it. But when you're continuing in that vein...
Negative Nancy's don't get the time of day. Just jog on, go somewhere else.
Yeah.
Don't have to like or follow our channel. Just move on.
Yeah, move on. Use your time more effectively.
Yeah. And we're just too happy, easy going. We just can't be bothered,
Yeah.
if you give us any negativeness, as I say, unless there's a way I can construe it that I think might be helpful for other listeners,
Yeah.
you're out of here. You're just gone.
Exactly. We're here to help people.
Yeah.
If you're not, waste your time elsewhere.
Exactly.
Anyway, on that note, so that was all about, our kind of intro to the podcast.
Yep.
So we need to introduce the podcast.
Yes.
So for those who are new, we like to name our episodes after something that corresponds with the episode number. So this is episode 65. These podcasts come out every single Friday. At the start, every episode was named after Formula One drivers because, there are loads of Formula One drivers who have the sort of low numbers. They're thinning out a bit at this point. So we've done other things. We've done football-related things, wrestling, etc. So I thought, let's have a look, see if there were any wrestlers born in 1965.
Mm-hmm.
So this guy, I'll give you some hints, actually.
A wrestler.
Well, yeah, he's in WWE.
Okay, that was a hint in itself, I think.
Yeah. I say wrestling, more a manager. He is the wise man. So he was Roman Reigns' wise man. But you might have seen he betrayed Roman Reigns last month, and he's now with Seth Rollins and...
He did the uppercut to the nether regions, didn't he?
He certainly did.
Oh.
The low blow, as it's known in the industry.
The low blow. And doesn't he call himself the advocate?
He calls himself an advocate as well.
Oh, God, but what's his name, though? I forgot it.
What is his name?
Paul Heyman.
Paul Heyman.
We actually tagged him on LinkedIn once.
We tagged him on LinkedIn, didn't we? Because, so Paul Heyman, welcome to episode 65, the Paul Heyman special. So he's been in WWE for 20-odd years now. Used to own a rival company, which was bought out by the WWE, and he moved across with. And so he's just a manager. So to put it in context, some wrestlers have a manager that walks to the ring with them and does a bit of talking for them, etc. And yeah, he referred to himself as the advocate for Brock Lesnar. Yeah, he's probably had different titles when he's managed different people, etc. But, we've said this. I think he's actually a brilliant advocate.
Mm-hmm.
Watch a little bit of his promo work. He's very good on the microphone, very good at, meaning what he says, very good with the pause. He commands attention.
Mm-hmm.
He really does command attention. And I might have mentioned this. I was listening to him on a podcast, and he said that his dad was a personal injury attorney in the US who did trial work.
Yeah.
And, so this Paul Heyman guy, we might have even thrown a clip in from him. Whenever he's addressing the audience, he'll go really slowly. Ladies and gentlemen, my name is Paul Heyman, but says it even slower than that, really commands the attention. And he says where he got that from was watching his dad do an opening speech to the jury. First time, so they must do opening speeches for the defence or whatever in PI, or actually I suppose he'd be a claimant lawyer, wouldn't he? So,
Anyway,
whatever. First time he stands up and addresses the jury, he does that. And so he picked up on that and a few other things from when his dad was addressing the jury. He uses those in his promo, and you can really see it shine through. I was surprised he wasn't a lawyer himself, but yeah, no, brilliant on the microphone, and he's managed some top talent over the years. So yeah,
there we go.
There we go.
Boom.
Anyhow,
onto the law.
9
minutes 15. Sorry, guys, if you're just here for the law, sorry. I would think that, we talked about advocacy.
We did.
We talked about trolls. Let's move on. So, a few things on the agenda today.
Yeah.
First things first, we were having a chat yesterday over some pizza.
We were.
If you remember, we were like, oh, this would be such a good segment.
We were saying to ourselves, it's a shame our chat literally wasn't filmed.
I know. Let's do 48 hours in the life of a criminal barrister.
Okay.
So we shared this on LinkedIn today, and it's doing the rounds. People seem to like it.
Yeah.
So people often ask, what's a typical day look like for you? And there's no typical day. So this is a very realistic snapshot in your life, John.
In my life, yeah.
Should I read it out and you can jump in?
Yeah, read it out. Let's jump through.
Okay. We do have a vlog coming of this day as well, so we'll keep it punchy.
Okay.
But here we go. Tuesday,
Mm-hmm.
12:30 a.m.
Yeah.
Arrived home from a fantastic stag do.
Yeah. So if you tuned in last week, you will have seen us record a podcast at 8:30 in the morning. And then not long after that, I went to the Five Ways Wetherspoons pub with my mates, where we got started for a stag do.
Your stag do?
My stag do, no less. My stag do. So it's 4 days, Friday, Saturday, Sunday, Monday. That's 4 days. Yeah, went to Prague. It was epic. Like, I knew it was going to be good, but my mates, wow, they pulled out all the stops for me. A few pranks on the way. Probably can't really share them online what they were.
No, you just imagine it's a gang of men.
Yeah, good group of
boys
lads.
that have all been through school, high school together. So you can imagine they got John good at various different points.
Oh, they did. There were 3 pranks before I got through security at the airport, let's say.
Yeah.
Yeah, they were good.
I would say if you want to find out what they are, come to some of our in-person events and, ask John afterwards when he's having a pint in the pub, because that's when you'll find out. And it's definitely a story worth telling, but not on a public platform like this.
So what happened was I sort of arranged the group chat initially and then pulled myself out and said, you guys just do whatever you want, sort it. The activities they arranged for me out there were brilliant.
Yeah.
Did all sorts. But, it's not a podcast about a stag do. But anyway, long and short.
You had a good time.
Had a good time. Shout out to the boys. Thank you for a fantastic 4 days.
Yeah.
So, yeah, as you heard, got back at 12:30 in the morning.
Okay. Next up, Tuesday.
Yeah.
9 a.m. to 5 p.m.
Yeah.
A rare day out of court, but still flat out preparing for 3 upcoming cases.
Yeah.
And catching up on all the work.
Yeah, pretty much, yeah. So I'd booked the day after the stag do off. And yeah, I had 3 cases in court the following day. It was only meant to be 2, but then something else slotted in last minute. So I had to prep for all of those. And then, yeah, loads of other bits and bobs, a few speed meeting things to catch up on, loads of emails from solicitors and things like that while I've been away. So yeah, it's just, even though it's a day out of court, it's still a busy day for you.
Yep.
Or for me, rather.
It was a very busy day. And it didn't end there.
It didn't end there, no.
Tuesday.
Yeah.
7:30 to 9 p.m.
Yeah.
Hosting the latest advocacy club meeting.
Yeah, so that was brilliant. Are we going to talk about advocacy club later?
We're going to talk about it later because
Okay,
it's going to bring in our questions.
Won't go into too much detail here then. So long and short, start of the trial series. Fantastic session. I enjoyed it. So nice thing to come back to.
Yep. Tuesday.
Yeah.
9 p.m. till 11 p.m.
Yeah.
Late night drive to Derby.
Yeah. So I needed to be in court for bang on 9 the following day, and I'll talk about that in a second. Why? So I'm an early, when I need to be, I'm an early riser, and I do loads of miles with this job anyway. So I'm used to getting up early. But I thought, just in case there's any snags, anything wrong with the traffic, I thought, let's get a hotel so we're 10 minutes away from court and we can be there. So we got this little hotel, didn't we? I don't know why, but hotels were stupidly expensive in Derby that night.
Yeah.
So, I mean, like, Premier Inn, you were talking like 180 quid. Whereas, we used to pay like 50 quid for a Premier Inn, aren't we?
Uh-huh.
So we stayed, just in some other random hotel we found, which we have a theory might have been an ex-Premier Inn, because you go in, purple curtains,
Yeah.
purple headboard. It had
The carpet was the same.
The carpet was the same.
bathroom was the same.
The bathroom was the same lino, same tiles, even the same dispensers for the soap. So either this hotel's been massively inspired by the Premier Inn,
Or it used to be
or
one.
it used to be one. Even when you flick the lights on, it's got the same of like the light in the bathroom.
Yeah. I think you're just showing that you spend far too much time in Premier Inns for knowing all of this detail.
I can tell you what, if Lenny Henry ever loses that job, I
You
think
can
I
step
fill
in.
Yeah.
Imagine you and your Scouse accent soon the Everton's Premier.
Everton's Premier, but the price.
I think Lenny Henry, I think you're safe.
I think Lenny Henry's safer.
Okay, so we drove to Derby. Wednesday,
Yeah.
9 a.m. till 12 p.m. So this was a very busy morning in court with you, John. So I'll let you talk people through what you had.
So this day, so it's probably easy to start by saying what I had on the day. So I had a first appearance in the morning, which is scheduled for 10, like all first apps are. I also had a CVP mention. So CVP means a video hearing to another court for 9:30. And then we had a trial in another court in the afternoon. So this is why I wanted to be at court for bang on 9, because, normally you have about a half-hour conference before a first appearance. I always tend to get there an hour before in case the client does as well. If we have an hour, even better. But half an hour is normally enough. So got there for bang on 9 and told the solicitors get the client there for 9 as well. So starting the conference, clients, good as gold, got there bang on time, good conference. And then 9:30, had to jump on my video hearing on a mention. Got through that. Then saw my clients again, so I still had a bit of time before our first appearance came up. And yeah, dealt with that. Had a bit of a wait in court because there were a fair few cases in, I think a few custodies, which obviously take priority. So that meant that we got away from court at midday.
Which was later than you wanted to.
Which was later than I wanted. And, this is the thing with being a barrister, and a solicitor. Well, actually, probably more so for a solicitor, particularly if you're a duty solicitor, juggling so many different things at once.
Yeah.
So, it's a skill that you need to have. It's not only juggling the hearings, it's juggling your different clients as well.
Yeah.
So it's quite a skill. It's, it's time management, it's people skills, etc. So 12 o'clock we got away.
Yep.
And we flew then, didn't we, from Derby to Warrington.
So 12 p.m. to 1:30 was a drive to Warrington with a very quick stop through a services on the way to grab some food.
Yeah, so we literally nipped in, got some McDonald's and pretty much we eaten on the way.
Yeah. And we had your pupil barrister with us as well, Sarah, didn't we? Really
nice. So Sarah came with us. So it's interesting. So we found out the day before she was shadowing me, and I looked at the name and thought, it looks familiar. And it turns out she's taken part in one of our competitions before.
Brilliant.
So it's a small world, isn't it?
It really is.
It's funny. My clerk was saying to me, after I joined Chambers, about 50% of the pupillage applications either mention me or mention Speed Mooting.
Brilliant. Okay.
Yeah, so we did that.
And then 2 p.m. to 4 p.m. was your trial.
A trial, yeah. So got there just in the nick of time. Had a conference with my client for the afternoon. Once again, people were still with us. So I had the conference with the client, and then we went in, and it was a Section 172 trial, so fairly common. So you'll find that, if you're a junior barrister doing crime, you'll get loads of these. Even if you go in-house with the CPS, you'll probably finally prosecute loads of these from the outset as well. So it's Section 172 trial effectively is if a car is caught committed a moving traffic offence. So generally speaking, it's speeding because, when you go past an automated traffic camera, what happens is the camera picks up the registration, sends a letter to the registered keeper of the vehicle, which is a notice of intended prosecution or a Section 172 notice. It goes to the registered keeper and says, please tell us who was driving at this time. So please tell us who was driving, or if you don't know. But if you don't respond to it within 28 days, it's a criminal offence. And that's what this offence was, not responding to it. But there was, a genuine defence raised by my client. So we ran the trial on that point. And he was found not guilty.
Boom.
And it was funny because we were chatting about opening speeches in the car on the way, weren't we?
Yes.
And one of the questions, I don't want to step on the toes of anything later, but one of the questions I got from somebody at the advocacy club is, how long could an opening speech be? I said, well, an assault trial might be 5 minutes, could be days in other trials, whatever. And then as we were driving to court, we were talking about that conversation. I said, I bet you're in this trial, though, this opening speech will be 30 seconds. And I was on the money.
Was it really 30 seconds?
Literally 30 seconds. As you've heard, the offence is.
Yeah.
Prosecutor's opening speech was on such and such a date. A vehicle was caught speeding. On this date, the NIP was sent. No response was received. I received the first witness statement.
Wow.
Yeah.
But another successful outcome for John Doe.
Successful outcome. Not guilty verdict from the magistrate. And client was very happy.
So next up, we had 4 p.m. to 5 p.m, drive home and catch up on missed calls en route. So you were on the phone to your clerks, the solicitors from the day.
Yeah.
I don't even know. You were on the phone for a lot.
I was literally on the phone all the time. I find this, whenever I drive home from court, I don't even get a chance to listen to music or podcasts or anything because I'm just literally on the phone all the time.
But it makes the journey go a bit faster.
It does, actually, it does. There's only so many songs and podcasts and all the rest you can listen to. So it keeps you a bit engaged, actually.
Yes.
So, yeah.
So we arrived home around 5-ish.
Yeah.
But you were quite lucky that you were out of court today as well. Otherwise, you would have had more work to do.
Yeah.
But luckily, because you did have a day out of court today, we got to go to Pizza Express for some dinner.
We did.
And then we watched the new Formula One film.
We did, indeed.
So we have a few Formula One fans that listen to us, don't we? So shall we give, without any spoilers, give your view on the film?
Yeah, okay. For those who don't know, it's Brad Pitt in a Formula One film. And, if you watch F1, you will have seen they've been filming at the tracks for the past, I think, 2 years, because I think it was 23 and 24, maybe even a bit of this year. So the whole idea is it was meant to be, the most realistic Formula One film ever, and there was some onboards and onboards from the cars, and they're going to use CGI. And we saw a sign the other day saying film for IMAX, and we're like, what does that mean?
Yeah, that was
and
insane.
we ended up in an IMAX theatre, didn't we?
Yes.
So in short, what IMAX means is you got your normal screen in front of you, but then screens down the side as well.
So if you can imagine, this was a perfect one for it, because it's driving, they're in Formula One cars, so you can see the Brad, his viewpoint almost on the big screen, and then around the sides of him, it's like you're in the cockpit of a Formula One car.
Yeah.
It was insane, wasn't it?
Yeah, it was really good. So I thought it was a good film, good plot. Just what I wasn't so keen on is, and this is my criticism of pretty much every car racing film ever, the racing scenes are just unrealistic.
Yeah.
And the reason I was disappointed by this film in that, because, you expect it in films, fine. But the whole premise of it is we're filming this at the races, we're doing this. And, so it should have been the most realistic F1 film ever. The racing scenes just didn't make sense. And are things that wouldn't really happen. Wow. So that was what disappointed me.
Yeah.
So good film. If you want a Formula One film, I still think Rush is a better film, though.
Okay.
Yeah.
There we
Rush
go.
is a much better film.
Mm-hmm.
But yeah, nothing wrong with
It's
that.
a good film, yeah.
It's
I
still worth
enjoyed
going.
it.
Yeah.
I think, for me, I said this to you, didn't I? I just think films in the cinema these days, I just think they just go on a little bit too long.
Yeah.
It was a great film, and I didn't pick up on the things that you pick up on, John, just because, I'm not a racer, so I don't know if it's realistic or unrealistic. I'm just like, this is cool.
Yeah.
Just along for the ride. But the last 40 minutes, I'm just like, how is it finishing yet? And I remember the saying, I love the John Wick films. I can't wait to see that new one. But I remember that for the last two of his films as well. It's just a little bit too long.
They're far too long, aren't they? Yeah.
What's wrong to the old movies that lasted an hour and a half? It's great.
Yeah.
Now every film is 2.5, 3 hours. It's just too long. But it was great. I think the film finished around 11:30.
Something like that.
Something like that. So we got home around midnight, and that was the
us.
end of John's 48 hours. So
wow.
I'd say that was probably more accurate. Typically would have been you getting home at 5 and then prepping for the cases the next day.
Yeah.
So you're quite lucky you got a night off.
Yeah, it was nice to do that.
Yeah.
Wasn't it? And I think as well, what I will preface this by saying is my practice is probably slightly different to a lot of criminal barristers, because I find a lot of criminal barristers do a lot of local work.
Yeah.
Obviously, there's still, everyone still travels to an extent, but, generally speaking, it's a lot of local work.
Mm-hmm.
With the way that my practice is split, and it's probably a 50-50 split between, general crime in the Crown Court and private motoring type cases. So I think my practice is probably about a 50-50 split there.
Yeah.
And so for that reason, particularly when you're doing the motoring stuff, you're on the road a lot, and that's what part of the reason I do so many miles.
Mm-hmm.
So probably the amount of travel I do is unusual for a criminal barrister.
Yeah, people probably do it occasionally.
Yeah, I think people do it occasionally, but probably not.
You're doing it constantly. Yeah,
I'm doing it constantly. So that's one thing that goes into my practice. So that's one thing just to bear in mind about mine being a little bit atypical.
Yeah. But still. That's an insight into John's life as a barrister and a business owner.
Yeah.
When we were at Pizza Express, we were having a chat, weren't we? And it was partly based on one of the comments we got on YouTube, which we mentioned earlier, about when they were making their feelings known about CPR and lawyers in general.
Yeah.
One of the things they said is, even lawyers even solicitors don't understand it. They have to use barristers. And I answered, no, that's not true. I'm a solicitor. I understand it. I've just explained it on this video. But anyway, and we were talking about, I wonder how much of it is true and how much of it is perceived to be true. solicitors like versus barristers.
Yeah.
Most people probably do think that barristers are a step above in terms of, you know, intelligence, but we were thinking it through, weren't we? And just saying it's just because of the roles. I mean, I know the roles blur these days, but let's keep it typical, you know, solicitors running caseloads back and forth, barristers stepping in for court and things. So the main role of a barrister is just to apply the law to the case and present the law, isn't it?
Yeah.
Where this main role of solicitors is to work every step of the way with their clients.
Yeah.
So that's why, you know, if you put a solicitor and a barrister side by side and said, tell me about the case of X and Z and how does it apply to this thing, the barrister probably is going to be able to articulate a better response.
Yeah.
Because that's what they do.
Yeah.
If you ask a barrister to sit in a room with 4 different people that have all got terrible, terrible legal problems and talk them through it, the solicitor's probably going to do a better job because that's what they do day in, day out.
Agree, yeah.
So...
And I think that's part of the thing, isn't it? Because, you know, as you say, coming back to that example, and they say, oh, if you just get barristers in. I think that part of the reason that the barrister comes in to provide advice is because, as you said, you know, they're the ones who see it in court and see how the law is applied practically.
Yeah.
It's not that solicitors don't know the law, it's just speaking it through practically how it's actually applied and how it plays out in court.
Yeah.
But yeah, 100% it's wrong when, you know, people have this theory that barristers are better, but no.
Yeah.
It's not, or as you say, it's a promotion, a step up. No, it's not. Absolutely equal, and they do completely different jobs.
Yes.
And that's why, you know, people, you know, you got barristers that switch and become solicitors, solicitors that switch and become barristers. Neither's better than the other, and neither is a step up at all.
Like, I guarantee from my time in private practice, you'll have your conference with your barrister, and it'll be an hour, 2 hours long, however long it is. And when it's finished, you will then have to go on the phone with your client and talk it all through with them again. And that's not, you know, that's not a diss at the barrister or anything. It's just solicitors, we know our client, so we'll did you get that? Oh yeah. And then they'll ring you afterwards and go, so what he's saying is we just, like, that piece of law that we've been arguing for 6 months, that's wrong. No, that's not what he's saying. He's saying this, and these are your chances in court, and you shouldn't take that risk because you can't give you great prospects on that one point. And so we have different roles, but they all come together to, you know, get the outcome that's needed for the client. So, I mean, listeners, do chime in if you have an opinion on this. But
100%, yeah.
The consensus we reached, didn't we, John, is that no one isn't better than the other. They very much both need each other.
Yeah, they both need each other. They both do complementary roles.
Yes.
100%.
Mm-hmm.
Because, yeah, I mean, you know, for example, I've done both jobs now, haven't I? I was a solicitor, crossed over, became a barrister.
Mm-hmm.
And, you know, there's a significant number of things that I don't do anymore.
Yes.
My roles about I can't do.
Yeah.
You know, I don't have litigation on my practicing certificate.
Mm-hmm.
And I'm glad for that, because it means that I focus on advice. It means I focus on courtroom advocacy, a bit of drafting.
Yeah.
And you know, the rest of the job is left to the solicitor, and you know, they do a significantly better job at it than I ever would if I was to try and squeeze it into my practice.
Yeah. And, you know, you forget as well, the solicitors are the ones instructing the barristers, so they know the law, they know what they want.
Of course.
So they know what the arguments are. It's just that the barrister is trained, because day in, day out, they can take those instructions that a solicitor's put on paper, on email, on a phone call, and turn it into a professional argument that is going to win, convince a judge or a jury. Like, that's what they do.
Yeah.
The solicitor's not sat behind the barrister in court going, I don't understand any of this.
Exactly. Yeah. It's just a perception.
It's a perception, yeah.
And it's amazing. You know, you speak to different people and you see the perceptions that they have. Like, most of my mates are non-lawyers, and, you know, the perceptions they have about how the law works, how we do things. You guys just do this, like, no, not quite. No.
Yeah. And it probably does cross over to other areas. Like, we use the GP and the surgeon analogy a lot, don't we?
Yeah.
So we say the solicitor is the GP and the barrister is the surgeon. So you probably would think yourself, you know, if your GP say, no, I'm going to perform this surgery. Oh, I mean, can you do this? Because they can do minor surgeries, can't they?
Can, yeah.
And you probably do think, oh God, I'd rather be in a hospital with a doctor, like a doctor or a surgeon, but they can do it. It's just, sometimes just needs to go to someone who does that one thing day in, day out.
Yeah, exactly. And, coming back to that example, the GP knows medicine. They've been to medical school for however long it is.
Oh, yeah.
So they know it inside out. I think, even if you think about it as like, I don't know much about football, but I suppose a football analogy can come in, if you think about different positions, they have the defender, the goalie, the striker, whatever. They're all footballers, but they just do different things within the same game.
Yeah, where I bet everyone thinks the striker's the best because they're the one that scores the
They're the one that
goals.
scores the goal, yeah. That's probably the same, because the barrister's the one that argues in court. They're like the striker, aren't they? Getting the final result.
Oh, I like that.
We just come up with our own little analogy,
That's
haven't we?
clever. Yeah, that is clever.
Yeah.
And I suppose all the other football players could be like the solicitors, the paralegals, the admin staff.
Yeah.
It's
Yeah,
so
I
cool.
suppose you think about,
I don't know enough positions.
I don't know enough. I'm just thinking on through here. Let's say you got a free kick that goes in or a corner. The solicitor's like, kick it in, doing the hard work beforehand, and then the barrister's the one that heads it in or whatever.
There we go.
Neither of us know much about football, so
I bet I'm going to say that the goalie is, like the legal assistants or the PAs or something, because they probably do save our bacon 20 times a day.
Yeah.
You're meant to be in a meeting now. You've got a call, oh, you need to send that letter out. Shall I run it to the post before you miss the last post? So I'm going to say they are the goalies.
Yeah.
Any other analogies and positions? Let us know.
Oh, yeah, we're onto something here.
We need to build a full football team.
Yeah. This video is brought to you by Speed Mooting. We are an organisation that help aspiring and junior lawyers. We run online and in-person advocacy and mooting competitions. We do online advocacy and public speaking training, and we run lots of other events to assist people on their legal journey. To learn more, visit our website, speedmooting.com.
Okay, moving on. So we have, I suppose this could be Commercial Awareness Corner and also a Learning the Law segment.
Okay, go on.
And I merge them both together.
Yeah.
So this is all about without prejudice.
Mm-hmm.
This is a term we like to use in the civil world. Talking about that, you don't really have an equivalent in crime, do you? But we'll come on to that in a minute.
Yeah.
There's been a recent case about without prejudice, so we thought we would have a chat about it.
Let's have a chat.
So take a step back first before I move on to this case. Without prejudice is a term that civil lawyers like to use on correspondence to each other.
Mm-hmm.
You can have it on a letter, or you can have it on a phone call between an opponent. You can say, can we have a without prejudice conversation? And it essentially means that you can speak freely. If you can't see me, I'm doing air quotes here.
Yeah.
You can speak freely without a fear of what you're saying being used against you in court. There are exceptions though, so this can only be used during conversations that are genuine attempts to settle. So it's to encourage people to reach settlement quickly, speak freely, and not be scared. Because you imagine if you and I were having a normal conversation now, and I say, oh, well, let's settle. I'll give you £5,000 now if we can settle. And you go, no. And then in front of the judge, you say, they offered me £5,000. So they know they must be guilty. Why would they offer me it like that? So that's what it's supposed to stop from happening. So you can make genuine offers to settle, and it can't be used against you in court. As I say, it has to be genuine. So you can't send a 4-page letter ranting about your opponent, stamp without prejudice on the top, and say you can't show the judge that. That's not what it's there for. It has to be a genuine attempt at settlement. Most commonly as well in litigation, on our letters, we will say, without prejudice, save us to costs.
Right.
And what that means is once the case has been determined, either settled or decided in court, that correspondence can then be used when the judge is assessing costs. So, for example, they might say to you, gosh, your correspondence is really high. I'm going to take some of that off you. And you can say, yeah, but I sent like five without prejudice letters because I was really trying to settle the case. Mm-hmm. And then they can look at it and go, okay, I'm going to take into account that you were doing a lot of genuine attempts to settle here. So you can have some more of those costs. So it can be used then. I've also seen it be used when I did my seat in real estate transactional without prejudice subject to contract, which is obviously a bit different because it's not in a litigation context. But it basically means, you're going back and forth agreeing these terms. If there's no contract signed, you can't then say, well, you're bound by this. You say, no, it was subject to contract and we don't have a contract yet. So none of this is legally binding yet.
Yeah.
Make sense?
Makes sense.
So the recent case is Morris v. Williams 2025.
Okay.
And essentially, I haven't read the full judgment, but I did see someone make a post about it on LinkedIn, which led me into this whole segment.
Yeah.
So it was a personal injury case, I think. And the claimant sent an offer without prejudice offer to the defendant and essentially said, if you agree to settlement, I will admit that I've been fundamentally dishonest in parts of my claim. But I'll only admit it, if you agree to settlement and you sign a non-disclosure about this dishonesty. So the defendant, rightly so you may think, rejected the offer and applied to court to waive prejudice because they'd admitted they'd been dishonest in this correspondence, which obviously destroys the whole claim that they brought against the defendant. And I believe prejudice was waived in that exception.
Wow.
So big case for without prejudice. I say that was a personal injury claim. So it's obviously something that can have big implications to civil litigation as a whole.
Yeah.
So bringing us back to commercial awareness, if you're interested in civil litigation, I would definitely go and have a read upon that judgment because it would give you a nice little talking point for any civil interviews you're going to.
100%, yeah. I was just about to say that. In civil interviews.
Yeah. So yeah, that is without prejudice. Hope that was helpful.
Yeah, I've learned a lot.
Yeah, so we were talking, weren't we, about how if that transpires in the criminal world at all, and it doesn't really.
Not really, no, because we're not really making offers per se. And so you do have, I think we might have talked about it 2 or 3 weeks ago, the basis of plea.
Yeah.
So, where you submit a guilty plea in relation to a less serious offence or the same offence but on less serious facts. So very straightforward. Let's say your client's charged with a Section 47 ABH and you say to the prosecution, will you take a plea to a Section 39 assault by beating, or Section 47, let's say it involves punches and kicks, will you take a plea on the basis it was one kick, one punch, whatever. That's straightforward example there. But you might have conversations like that, but they're not really sort of protected by without prejudice or anything. But the difference is if you were making that offer, then presumably you're in the ballpark of some sort of guilty plea at some point anyway, aren't you?
Yeah.
You might be heading towards a Newton hearing, in which case it'd be coming up because if your instructions are, well, there was no assault or it was self-defense, or you wouldn't even be in the realm of discussing a basis of plea. And quite often not quite often, it's on the form. So if you're in the magistrate's court when you're entering a not guilty plea and you have to fill in the form on behalf of your client, there's a question that says, would you be willing to put forward a basis of plea? And then likewise in the Crown Court on the PCPH form, would you put it in? And so sometimes, it does go in, and it would be before the judge. So for example, let's take the same example, or a bit more serious one. Let's say it was a wounded with intent, Section 18, and you might say, well, it was unintentional, that's the defence, and you've put in a plea to a Section 20 basic GBH, gives the jury the chance to convict on the lesser offence, and you put in the basis of plea anyway. But yeah, so no, we don't really have without prejudice in the criminal world. So yeah, so that kind of thing wouldn't happen anyway. But it's one of those. There's no doubt there's the perception out there that that's what goes on, or the secret side deals and all that kind of stuff.
Believe it or not, we are quite honest as lawyers.
We have a code of conduct, and the reality is, people comply with it anyway. Because if you're coming into this profession, you're coming in for a reason. You're coming in because you want to do a good job. So you comply with the code of conduct. And if you were someone who's got a bit of a sharp practice, and it's such a small profession, you get found out so quickly that you've lost all credibility and you can't do the job properly. Once your credibility, once your respect is gone, you cannot do this job.
No.
So, you know, you very much need to play this game with a straight bat. You need to be genuine.
Yeah. I was just gonna say, what's the solicitor's name on Silk?
Oh, yeah. I know you mean. The guy with like the 3-piece pinstripe.
Yeah, and he's like in the pocket with all the drug dealers.
Yeah.
I want to say Jimmy, but I don't know if it is Jimmy.
Yeah, I don't know if it was. If anyone knows, comment down below.
But yeah, I was gonna say we all know how he ended up. No one wants to be there. So yeah, we take honesty very, very seriously, and you know, we have to uphold the rule of the law, and we perform our duties.
Yeah, as I say, comply with your code of conduct, comply with your ethics. If something feels wrong, it's probably wrong.
Yeah.
And if in doubt,
don't do it.
If in doubt, don't do it. I was going to say, you know, rings. You know, if you genuinely don't know, ring someone. But yeah, gut feeling. If in doubt, don't do. Yeah.
Shall we move on to Ask Speed Squad?
Let's do it.
We're chuckling because I keep saying I want to find like a theme tune for the Ask Speed Squad segment. I was saying to John earlier, would you like sing Ask Speed Squad into a microphone with me or something so we can make a jingle? You don't want to hear John sing though. No offense, John.
Oh, wow.
I mean, if you ask John, he says that he sounds exactly like Gary Barlow.
Yeah. Should we tell a story?
Maybe another time because we're on 45
Oh,
minutes.
Yeah.
Okay, so time for Ask Speed Squad.
Yeah.
While I get some questions up, do you want to just tell people where these questions are coming from?
Yeah. So this week, as in this past week, we had the first legal session of the Advocacy Club that related to our criminal trial. So across the course of 3 months, our members are going to do a full criminal trial. Opening speeches this month, witness handling next month, closing speeches the month after. So this month, as I say, was all about the opening speech. Members delivered the opening speech in an assault trial. And at the end of the session, I opened it up to a Q&A session. And we got some fantastic questions. So I answered lots of good questions on the day. But I wasn't able to get through all of them because we had so many fantastic questions. So those that we couldn't answer, we're going to answer now.
We are indeed.
So I think some of the questions relate to the facts of this particular case. So in very, very simple terms, it's about our complainant who's gone to the pub on I think it's a Saturday evening. He's there for 3-4 hours or so, has a few beers. Another friend joins, so there's a big group of friends. Another friend joins them. About 9 o'clock in the evening, he goes outside to take a phone call. He then sees the defendant, who was an old friend of his, but he's fallen out with, walking up the street. Defendant comes over, they have a bit of an argument, and then it's alleged that the defendant punches him to the left side of the cheek. The other friend, the female who comes to the pub later on, she steps out at this point. She sees a bit of the argument. Now, she doesn't see the punch, but she kind of sees the complainant turn around holding his face. The defendant walks off. The defendant gets interviewed and he says, no, categorically, except I had an argument, but did not punch him at all. So the defence is that this never happened.
Yeah.
So the issue is, did the punch happen or not?
And what was the defendant charged with?
Yeah, sorry, I should say he's charged with a Section 39 assault by beating, and this is a magistrate's court trial.
Got it. So first question,
Yeah.
which you might have to go back to your CPS charging brain for this.
Okay.
Why would this not have been charged as a battery under Section 47 of the Offence Against the Person Act? Because there's a bruise.
Okay. Battery is just another name for an assault by beating. Okay, so this falls under Section 39. Now, Section 47, on the other hand, is assault occasioning actual bodily harm.
Yeah.
So you need actual bodily harm for that. So as a general rule, if you had sort of broken bones, you'd probably go down the route of an ABH, unless there are very serious ones and it becomes, a GBH. So I imagine if you'd broken someone's leg, you're probably in the realm for GBH, but no real broken bones here, no broken eye socket, nothing like that. It's a bruise. Now, there are certain circumstances where you possibly would go down the road of going an ABH. So if his face was completely black and blue, you'd probably think about that. This was a small red mark, basically. So just about within a
Yeah.
the realm of a Section 39. And it quite often is a bit of a judgment call. So there are some that blur the lines where you can sort of go down one road or the other. Whereby, you're not quite into the realm of, cut skin or broken bones or anything, but the injuries are just about enough that you go down the road of ABH.
Yeah.
With this, given how minor the injuries are,
Yeah.
you'd stay with it at 39.
Yeah. So if you were the prosecutor on this case and you got there to deliver the opening speech, you wouldn't particularly look at this and go, "This should have been a ABH."
No. It's a single punch, a little bit of pain for a few days. He's, fine afterwards, not even knocked down to the ground. So I think when you take all those factors into account, and the CPS has a really, really good website. So if you go on there and if you search, Section 39 assault CPS, you'll look at a lot of their guidance that they go into. So yeah, that's why I would do that. But another prosecutor might take a different tact on this and say, well, it has caused actual bodily harm there. But I think, given how minor the injuries are, it's a red mark on the cheek. My personal approach on this, I'd stay with it at 39.
Yeah, it's like everything, isn't it? You have to take the merits of each case, and there's elements of discretion, and people's opinions may differ.
Yeah.
But in this case, we say Section 39 is fine.
And you get this all the time. You get people that'll pick up a file and they go, "Oh, I can't believe they've charged that. I'd have only gone down this road on it."
Yeah.
A big one for that is stalking and harassment. Where the lines blur on that one.
Yeah.
One course of conduct, someone would say, well, that's clearly harassment. Another, someone would say stalking. So, and that's another one where the lines can sometimes be a bit blurred.
Okay.
Yeah.
Next question about the facts. So, do you remember all the people's names? Because this question names them a lot.
So, Alex May was our complainant.
Yep.
Katie Clear was the witness.
Okay.
And Adam Printer was our defendant.
Okay.
I'm glad I remembered
That's
that.
very well. Yeah. This talks about Katie and Alex, so you'll understand it now because you know who they are. So I spotted an inconsistency in Casey's witness statement.
Mm-hmm. Oh, okay.
I
wouldn't point out what the inconsistency is yet.
Okay.
Because people are going to be doing cross-examination and the like next month.
Okay. I'll just leave it there for now. So I spotted an inconsistency in Casey's witness statement.
Okay.
I thought this may be important. Should I have noted this in my opening speech, noting I'm for the prosecution? And she references, we should mention, I don't know if you mentioned this before, how the advocacy club works is people are split off into small breakout rooms. Yeah. You perform the advocacy together and then you give peer-to-peer feedback before coming back into the main room where John gives some general feedback and answers live questions.
Yeah.
So they also mentioned that another person in their breakout room was of the opinion that they shouldn't stress the inconsistency too much because they're for the prosecution.
Well, yeah, I mean, there's that. And also, you're not going into massive detail on that, as I mentioned, you're not going to go chapter and verse on what every single person says in the opening speech. And that the prosecution, well, the defense are going to pick up on that in cross-examination, if there's any major inconsistencies. And then you will address that in your closing speech because you don't know how the evidence is going to come out.
Yeah.
So this is why I was saying about, you be careful about, go, this person will say this, because you don't know how the evidence will come out.
Yeah.
Once again, you're for the prosecution, you're not there to do the defense's job for them effectively. Obviously, you've got to be fair, you've got to be open.
Yeah.
But in terms of anything like that, so I think what you'd be doing is, obviously, you're going to address it, you're going to say, you're going to hear from our complainant, this is what happened to him. Such and such was, Katie Clear, she was the witness. She will say that she saw whatever. But in terms of minor inconsistencies or, even potentially majors, etc. I mean, if there was a major inconsistency that was going to blow the case apart, it probably would never have been charged anyway, or that person would never have been called.
Yeah.
But yeah, no, you're not there to be pointing out inconsistencies because you're not there to take the sting out of your own case. Because, think about how to say, well, this person's inconsistent with this person. But, you'd have to go, but.
Yeah.
And you can't.
So you're just going to have that in your mind. Oh, there's an inconsistency here. Let's see how it comes out. I need to be ready to combat it.
But, just thinking that thought through, if you're for the prosecution, you're going to want to take this thing out. So you'd say, well, there's these inconsistencies, but it can't undermine their credibility because you haven't heard how they're going to give evidence.
No.
You don't know whether they were credible witnesses. You don't know. So I just wouldn't be addressing it at this point. You're addressing in general terms what those people are going to say, why they're giving evidence. It's then for when their evidence actually comes out, if there are any inconsistencies, for it to be dealt with at that point. And then, of course, when those inconsistencies do come out, in your closing speech, you're going to need to take the sting out in whatever way you're going to take the sting out.
Okay, hope that was helpful.
Mm-hmm.
What is a proof of evidence, and how does it differ from a Section 9 witness statement?
Okay, so Section 9 witness statements are served by the prosecution. Section 9 witness statement is just a fancy word for saying witness statement. So any witness that the prosecution proposes to call, they will obtain, or the police will obtain, a statement from that person that then gets served on the defence in advance. If the defence look at that statement and think, well, that person doesn't really give controversial evidence, doesn't really harm our case, we can agree that person's evidence, and it means at trial their witness statement will be read out, and you'd say it's read Section 9. Okay. If the defence say no, that person's evidence is controversial. So in this particular scenario, of course, your complainant's evidence is, if you're from a defence point of view, your complainant's evidence is controversial because you say, well, no, the punch never occurred. So you need that person to come to court. You need to cross-examine them. The proof of evidence, on the other hand, is effectively the defendant's witness statement, and it's obtained by the defence, and it's the defence solicitors will speak to the defendant, they'll take a full proof of evidence, get signed. That is never served on the prosecution. There's no obligation on you to serve it, and you wouldn't do so. It's there purely for whoever the trial advocate is, whether it's counsel, whether it's a solicitor, so they know what the defendant's evidence is going to be, proof of evidence. And therefore, when it comes to trial, when the person goes in the witness box and the defence barrister is examining that person and getting them to tell a story, they've got a framework to work from, the proof of evidence.
Yep.
So that's the difference. It's effectively the same thing. It's just that the defence version, which is the proof of evidence, is never served on the other party. And it's there. It also helps if, let's say you had a trial and, you know, your counsel, you've just been instructed on this trial, your solicitor send you a brief, send you proof of evidence, send you all the evidence, etc. And let's say your client doesn't turn up and the trial has to go ahead in their absence. If you've got a proof of evidence, you at least know what your client's instructions are, and you've got something on which you can cross-examine the prosecution witnesses. If you were instructed and you had no proof of evidence whatsoever, well, you probably have to withdraw at that point. So that's the other benefit of it.
Okay. What do you draw from to make your opening statement?
So mainly the witness statements, to be honest, because the witness statements are the evidence. So that's what you're using. So you're using the witness statements themselves. If there's any other evidence that's going in, then you'd include those as well. So, for example, any exhibits. So quite often in complex drug supply cases, particularly where, you know, you've got so many defendants, so many people at different layers, and there's a lot that you need to prove. Your opening speech, which, you know, needs to set the tone, the defense, the jury need to understand what your case is going to be all about, and that's why, you know, could last 3-4 hours. Your opening speech, you might throw some exhibits in as well, some photographs of, you know, houses that have been searched, some of the drugs that were seized, some of the paraphernalia, just to put things in context and also to keep the jury awake as well.
Yeah.
It's not controversial to do because the exhibits are going to come out at some point anyway. So so you might include photographs of exhibits and things like that. But yeah, your opening speech is based on the witness statements that are in your in your brief.
So you're essentially summarising what your witnesses are going to say before you call your witnesses.
You're telling a story.
Yeah.
So it's, I think the analogy we used is it's like a movie trailer. So so that the or a blurb on a book, you know, that's what the opening speech is. You're telling them, here's what the case is all about, here's what you're going to hear.
Yeah.
So that everything's put into context.
And do you say, this is another question, do you also say what you think the defendant is going to say? So our witnesses are going to tell you this. The defence is going to say, but that's not what we submit. We're submitting this.
Yeah,
we're going to show you how.
Yeah. So if you've got a defence interview and also if you've got a defence statement, you'll know what the defence is.
Yeah.
So you'll say, here's what the prosecution's case is. The defence, on the other hand, will be raising the defence of whatever. In interview, he said, you know, you just keep it very general. Despite this, we're still satisfied that you will find that the offence was committed to the criminal standard.
Yeah.
You know, whatever, something like that.
Last question. So, in this particular case, the police officer is not called as a witness. So, should we still mention what was said in the police interview?
Okay, yeah, fine. So this comes back to what I was talking about before about Section 9 statements that can be read and agreed, etc.
Yeah.
So within the bundle, we included a little paragraph at the end just to say a police officer attended. I might have given him a name, I can't remember. He was the officer in the case. He attended the pub afterwards, took the statements from the complainant and his friend Katie Clear, and then I think he conducted the interview as well. I can't remember. And so I threw a little paragraph in just to explain that and said his statement wasn't controversial, therefore he's not being called. Okay. Now, in real life, you would have a witness statement from the officer saying all of that. And I suppose I could have included a statement in there, but I just didn't want to confuse people by having an extra statement.
Yeah.
So that's why I just included that little paragraph. But yeah, so you'd still mention the police interview because the police interview is going to come up. And what we'd done was we just included a summary. And in the magistrate's court, what happens is within your case summary itself, it's called an MG5 documents case summary. You normally have a quick paragraph, which is a summary of the interview. If you accept that that summary is accurate, that goes in as the police interview. So in most cases, it does. And in this case, we just included a summary of the interview, so that goes in. So yeah, so you can absolutely make reference to the to the police interview in there, because although the officer's not going to give evidence, he's not giving evidence because his statement, which hasn't been included, would be read anyway.
Okay.
So yeah, so you can see how the police interview is going in any event.
Yeah.
In the Crown Court, on the other hand, what quite often happens is you'll have the officer in the case come to court and you'll have a full transcript of the interview, roti we call it, and the prosecution barrister and the police officer will play out the roles and they'll read out the interview verbatim, word for word. In the magistrate's court, unless the interview is disputed, or so, unless you look at the summary and your client says that's not what was said, or I actually said this and it's not included, unless that happens, you wouldn't be going down that road. So yeah, so the summary would just be read.
There we go.
There we are.
That is the end of our questions on the opening speech.
Some good questions there.
There was some good questions. And if you have any more, or any questions about anything whatsoever, anything to do with the law, about life in practice, about John and I, send them in to us, info@speedmooting.com, or drop us a comment, drop us a message, and we will answer them on next week's Ask Speed Squad segment.
Absolutely. Brilliant. Well, that brings us to the end. I think we've been recording.
Yeah, this is a long one.
Long one, yeah. Lots to talk about. Getting good, these episodes, aren't they?
Yeah, I think we promised everyone a nice long one after we recorded the last one of 8:30 in the morning before John went on a stag do. So
to be fair, though, we thought that one was going to be like 5 or 10 minutes, and that ended up being half an hour.
Yeah,
as
we
well.
just can't shut up these days.
Really can't. So much to talk about.
Yeah. And hopefully to the person that left that comment, there was enough law in this one for you.
Yeah, fingers crossed. Fingers crossed. And, we joke, but any other good comments about our podcast, constructive comments, whatever, just keep dropping them in. We're always happy to...
Yeah, we've been doing this for just over a year and we're still learning and evolving constantly. So we do love your comments and your feedback. So bring it on, guys.
Yeah, bring it on. Bring it on. So that brings us to the end. Have you enjoyed recording this one, Hayley?
I've enjoyed recording it, John.
Yeah, likewise, I've enjoyed recording it. Hope you've enjoyed listening. If you're still listening at this point, in the comments, drop us
Without Prejudice.
Without Prejudice.
Let's get a civil one in there.
Let's get a civil one. Are we getting them to do it in quote marks? Because don't you always do it in quote marks as well? Without Prejudice, save us the costs.
You don't have to put it in quotes.
Right,
we usually put it in like bold italics. There's usually something to make it stand out.
Yeah.
You can do.
Yeah.
Without Prejudice, or the finger over the mouth emoji.
Oh, yeah. So, yeah, that brings us to the end. Next week is episode 66.
Ooh.
It should be a good one. If anyone's got any thoughts of who we should name that one after, let us know. But until then, take care. Bye.
Bye.
Enjoying our videos? Then we'd be super grateful if you could take a moment and subscribe to our channel.